Well, item 7, Millard. Item number 7, Millard. Kindly grant, bundle is misplaced, Millard. Kindly grant 1 week time, Millard. I inform.
You are representing?
I am representing on behalf of P. Devendra, Millard. I inform Architect also, Millard.
What is the
He's here. 1 week time, Millard.
It is under the caption for dismissal. I'm not remembering the caption. Okay, it will be like that only. I'll adjourn to.
Possibly posting the same caption.
Yes. 2111.
21. Much of it.
Page number 2, 12 to 22.
Two options number. One is numbered, another is not numbered minor. And then you split minor. But I didn't have
Along with 15, item number 15. Next.
Next.
Page number 3, 22 to 31.
Dated them.
One is numbered, another is not.
What happened to the notices, Amma, in this matter? Notices are.
That's my. One is.
It is not in admission caption. It is in interlocutory. That is the reason I'm asking you.
With the delay, I find.
It is already admitted. After admission, only number has been allotted. Which one?
Item 15, 1 5.
Item 15, 477. Yes, 477 of 23. It is not admission.
It appears there is a delay petition. It appears there is a delay petition. Therefore, it's not numbered.
No, she says it is in admission. It is not in admission caption. There is a delay coordination petition is there. It is in 1711, Amma. 1711, next matter.
Page number 3, 23 to 31. Number 4, 32 to 42.
Item 5. Lot of time petition. Item 41 to 43.
Item 41 to
43.
43.
This matter 2 weeks. That's it. Informed already.
Page number 5, 43 to 58.
And adjourn.
Lordship, item 54, Lordship.
Item 54.
Have it next week, Lordship. Inform to other side.
You are representing?
Petitioner, appellant course. Inform.
Both counsel are present. At request of the counsel for the appellant. You said you have informed. Counsel is available here.
Yes, Lord.
Whom you have informed? Counsel? Whom you have
I
informed?
will serve with. I seek her inform, Lord.
20 to 11.
Okay.
Page number 6, 59 to 76.
Item 60. Item 60.
Item number 69.
60.
68.
6.
Item number 68. Mohan Krishna Garu and Mohan Krishna Garu is online.
He informed me that he will take time, Your Lordship.
Counsel for the appellant appeared through hybrid mode. Counsel for the respondent is present. At request of the counsel for the respondent posted to 20 to 11.
Item 60. Let me take my bundle is 60.
60, sir.
Yes, 60.
60.
I'm Sitaram. I informed Ms. Madhav Reddy. Morning I called him. 2 weeks. 2 weeks. 21st. 21st.
Page number 7, 77 to 78.
My lords, item 78, my lords. Kindly taken up the matter of 2 weeks, my
You are
lords. I appear for the respondent, my lords, informed the other side, my lords.
I will adjourn after the other side available.
Page number 8,
Please.
79 to 87.
Submission, my lord, first appeals, my lord. Last occasion respondents took time, my lord, was appeared on 6/11/23, my lord, was not listed, my lord. Kindly list the matter tomorrow.
What is the urgency for tomorrow?
My lord, seeking,
The case is of the year?
my lord, 23,
20.
fresh matter.
Fresh matter. What is the urgency?
My lord, the lower court is proceeding, my lord.
Then you have to obtain some stay or something.
My lord,
Have you filed any stay application?
yes, my lord, suspension application I filed, my lord. They took time for counter, my lord. They are not.
Monday 2014.
Well, it's one review petition in a CRP. Order passed by Justice Venkateshwar Reddy garu. It's been allotted to my lords. This matter came up just before the Dashara vacation, and the other side, without informing me, had taken time. Well, now the matter is posted for 13. The issue is that the court had directed me, court has dismissed the CRP in my favor, but the court had directed me to pay the admitted rents. What is that admitted rent has not been clarified, and the next date of hearing is 13. That is being held against me. My lord may post it tomorrow. It's a small clarification my lord may have to give.
Friday.
The 13th of November, the matter is posted, my lord. My dear.
13th November is holiday for us, no?
But my lord, that is what it is showing. The lower courts have formally, it's not been declared as a holiday for the lower court.
10th. Friday.
CRP 520.
Hmm.
Straight on 15, then, but it was not displayed. Press the action.
23rd.
Representing the after. Then the AS number 88 of 2020. Actually, you missed a lot of time. The application is pending, maybe was the order in the file.
Later.
16th. 16th.
The Lordship permission, my lord.
Yes.
CMA 1133 of 2011. Lordship directed to post to yesterday, my lord. Yesterday also not listed. I request tomorrow or day after tomorrow, my lord. Finally,
Right.
matter.
Friday. Next.
Tomorrow,
Subject
my
to
lord.
lordship.
Friday.
Much obliged. Much obliged.
Subject to lordship kindly.
Yes.
Item 74, your lordship. Sorry, your lordship, I missed that. Lordship, may this maybe have it after 2 weeks, your lordship.
Item number 74, you are representing?
Four. Respondent, your lordship. I informed the other side, your lordship.
Okay, after the other side available, I'll adjourn. Next.
Obliged.
CMA 310 of 2010.
I'm appearing for the appellant, madam.
CMA is dismissed.
Obliged. Number 2.
CMA 902 of 2010. CMA is dismissed, confirming the order dated 31/8/2009 in WC 6 of 2005 on the file of Commissioner for Workmen Compensation, Deputy Commissioner of Labor, Nalgonda. There shall be no orders to close.
Much of.
CMA 109 of 2019. CMA is dismissed.
Much of. Number 4.
CRP 2941 of 2012. CMA is dismissed.
Number 5.
CRP 3214 of 2012. CRP is dismissed.
May it please your lord.
$565. Item 1408. Judgment. CNA 1408. 1408 of 2011. The caption for judgment loan. కాజు లిస్ట్ అన్ని తప్పులు తడకలు ఉంటున్నాయి, ఒకసారి వాళ్ళు పిలిపించండి అని పెట్టమ్మా. నెక్స్ట్
In fact, in this case, Your Lordship, I already argued twice, Your Lordship, the disability assessed by the doctor is 40%, but the commissioner took it at 100%. In fact, the other side counsel is not coming, Your Lordship, since last occasion.
the counsel for the appellant. No representation for the respondent. In spite of opportunity given.
For order serial number 9, you are ready? Please make that ready.
I'm representing Raju Rashid.
చేసేద్దాం.
Examined. But he stated that, my lord, that according to the policy, only driver was covered, not the cleaner. That was the point raised in the appeal also. That your lordship may kindly see at page 7 of the commissioner order, my lord. The opposite party number 3 having ensured the opposite party number 1 covering the liability in respect of the said vehicle, so and so. Insurance policy so and so issued in favor of Limbagri, Siddipet, the opposite part number 2, and they said insurance policy was valid. That again, the driver of the bus was holding, that is another routine in this thing. The opposite part number 3 witness stated that in his deposition that the insurance policy was covered only for one employee, that is drivers only, but the deceased cleaner was not covered under the policy. As seen from the policy, the insurance company collected the amount for WC to employee and also collected the amount compulsory PO to owner come driver. In the deposition, the RWN admitted that the deceased was the cleaner in the accident bus and also admitted that there will be a cleaner in such buses. However, the said policy covers only one employee, does not exclude the cleaner. Therefore, his argument is not tenable. That is the finding. Running page 7. So, the policy clearly shows that only driver, one employee was covered to the bus, private bus. But he is a cleaner. For cleaner, a separate premium is to be collected and coverage should be there. In the absence of the liability of the insurance company for payment of compensation to the victim, bus cleaner does not arise. Under your lordships aware that under the policy in particularly Workmen's Compensation Act, the driver as well as one employee covers. One employee is not defined whether the cleaner or any other person. But here it is the case that cleaner died yes. No. He sustained injuries.
ఇది తర్వాత చూద్దాం. I'll reserve time next. Record పెట్టండి.
May I see the policy for a moment?
Policy. Insurance policy, Exhibit B1.
If the cleaner of the bus covered under the policy, there is no ground in the appeal.
Liability of passengers. ఇది వర్క్మెంట్ ఎంప్లాయీ సెషన్. One employee. Second page. Once.
Sir, I will submit in a minute, doctor.
Sir, council given. Once, second page. Next matter. Next matter.
Yes, matter was filed by the lordships on 12th of therefore orders.
CRP 114 of 2019. CRP is allowed. Setting aside the order dated 15/9/2018 passed by the Joint Collector, Vikarabad District, is allowed by condoning the delay of 424 days on payment of cost of ₹1,000 payable by the protected tenant revision petitioner to the landlord's respondent 529 within 2 weeks from today.
Much.
The applied authority is directed to take up the appeal filed by the revision petitioner under Section 90 of the Andhra Pradesh Telangana Tenancy Act and shall pass necessary orders thereon within 4 months. I'll reduce the time.
Yes,
From
3 months for order.
3 months is okay.
That is enough. 3 months from the
After
date
payment of
of
cost,
order.
after payment of cost by the revision petitioner as directed.
Also, can direct office to furnish copy.
Sure.
Each and every-
Copy is also ready. Sure.
Obliged minutes.
The petitioner we have to pay
No,
last month.
yes.
Yes, petitioner's counted.
But that one employee, what is there?
It is
No.
not clear whether it is the driver or the cleaner
No.
or a laborer.
Yes, but
There is ambiguity.
at the above para, driver and owner come, driver, both are covered. As per the policy, just now has, and under that, beneath that, but one employee covered. It is not different whether he was a cleaner or, so ambiguity is there.
That can be taken.
Yes, Muller.
That's-
So Lord should be dismissing.
I'll pass orders later.
Yes.
We have many other cases. Yes, next matter.
This signed documents of 11 and 16. Put together. Declaration suits. Yes. 40 page and 40.
11 and 12, sir.
11 and 16.
11 and 60.
16. What is
Yeah.
the declaration suits for contracts and practices. What's the condition?
Issue notice to the respondents. How many respondents are there, sir? Yes. Issue notice to the respondents 1 to 6. Respondents 1 to 6. With vote as well. Post it. It is Hanmakonda. It may take time, sir. I'll post it at month 1/12.
Yes.
1/12. December 1st. Both the matters. ఇది పక్క పక్కన రావాలండి. ఇష్టం వచ్చినట్టుంది కాజ్ ఇష్టం తప్పు. సేమ్ కౌన్సిల్ కదా 11 and 16. మధ్యలో వేరే వచ్చేసి. Are these two matters are connected, sir?
It's actually restrictions. Two different suits were.
Okay. 1st December. 1st December.
Successfully plaintiff in the suit for specific performance applicable. Suit for specific performance was filed seeking specific performance agreement of sale in respect of a plot land. That is essentially this will start allowing that I guess that sale chance within stipulated period 2 months. Assuming that no conditions are imposed on the vendor. What should I kindly see the judgment? The event post me that page 29. Page 20. Conclusions drawn with. For 5 lines more. Thereafter, it was not materialized.
Is it
It was not executed.
Is it internal page or?
Running page 29, internal page 20. That is part of para 20.
Part of 20.
Para 20 starting at page 29, 28, running page 28.
Okay.
I read the whole paragraph.
Yes.
20 minutes. Virtually, this is a matter of balancing the claim of both parties as against each other in the light of forum document evidence. Notice there is no dispute that the plaintiff had entered in agreement of sale with defendant to purchase the suit schedule property for a total sale consideration of the search. Having accepted the offer, plaintiff had paid earnest amounts of rupees so and so, and agreed to the balance amount of 15 lakhs within 2 months. Thereafter, it was not materialized and due to rival claims, regular sale was not executed with the parties. The recitals under Exhibit A1, agreement of sale date was 12 and 2015 clearly indicate that plaintiff has to pay the balance sale consideration of rupees 15 lakh by 12 to 2015. So time is the essence of the contract. The plaintiff had not paid the balance sale consideration amount within the stipulated time as agreed, and no notice was served on to show that plaintiff had made effort to express readiness to willingness to perform its part of the contract within stipulated time. As per the terms of the conditions mentioned in the agreement. No endeavor made to send reply notice, legal notice sent by the defendant dated 29 June 2016. Under Exhibit A4, in fact, filed the present suit on the pretext that the measurements of the suit plot are not in accordance with the title deed of the defendant is well and wrong. This here Lordship may kindly notice 2 factors. One is the date of agreement 12/2/2015. Next one is 12/12/2015 time stipulated. the payment of state consultant. Thereafter, Lakshmi kindly notice the date of the legal notice. 29/2/2016. Court rejects my claim on the ground that I did not reply to this notice. Lakshmi, can you see the decree date of filing of the suit? That's page 6. 20th January 2016, I filed this suit. By the date of filing this suit, no notice was issued. Subsequently, this notice was issued. Person of replying to this notice did not reply. That can't be put against me is my perspective. Then during the course of the trial, throughout there was tax for not alienated. Here also I am seeking emails. Lakshmi, kindly protect my interest. So in this the appeal is my interest.
Subject, my lords, I received the papers yesterday itself. I requested 2 weeks time, my lords. I got an instructions, oral instructions that he has alienated the property after the decree of the suit, my lords. And in this matter, my lord, subject to your lordship's, my learned friend said, in the written statement also we have stated that if we are ready to pay the 15 lakh, the balance sale consideration, we are ready to execute the sale. Till now, till the date of decree, he has not even shown any interest, or he didn't came up for the ready and willingness to perform this, to execute the sale deed. I have said so, my lords. Let me give 2 weeks of time, my lords. In the meanwhile, I will
Say that the property has been already.
my oral instructions are that they have alienated the property because after decree of the suit, my lords, not after dismissing of the suit, he has alienated it. It's the oral instructions from my counterpart. But I have to get instructions in clear, my lords, because till that time I didn't receive any instructions from my counterpart. Only he has stated that he has alienated the property, but that is, my lord, I have to get the sale deed. Whether he has executed the sale deed or not, I am not even aware. Yesterday even night, I contacted my counterpart in this case also. My lords, lordships may kindly see the written statement which I have filed. Exhibit A4, my lords, he has said that Exhibit A4 after execution of the sale deed. My lords, in my written statement also I have stated that if he is ready to pay that 50, the balance sale consideration, we are ready to execute the sale deed. They have executed the memorandum of understanding, my lords, which is marked as Exhibit B1. And in that also the court has taken into view that, my lord, there is they have stated that there is some pressurizing, but the court has come to the conclusion to that aspect also, my lords. And he filed one IA, my lords, seeking for measurement to appoint an advocate commissioner for fixing of the boundaries. That was also not pressed. The main contention in the rival is that, my lord, that the boundaries are not properly done. He filed an IA. That was he has not pressed that IA also. That was also stated in the judgment itself, which is in internal page number 21. And there is no such order copy, my lord, that the status quo has been granted. The order copy is also not even filed before the court. It's said so in the affidavit. That's it, my lords.
Judgment is on 18th August only.
Yes,
In
ma'am.
2 months, the property has been alienated.
It is so, they have said so, my lord, but I have to get clear instructions into to that aspect, my lord. My lords, well, kindly see internal page number 21 once, my lords.
Say paragraph or the page number.
Page number 21 of the internal judgment, my lord, because there is some confusion in the judgment which has been served to me. The internal page shows, the page number shows 28 and internal page of the judgment is 21.
Paragraph number check.
It's in continuation of the second para, my lords. If your lordships, my lords, kindly see page number 3rd line from the top, my lords. Even it is apparent that the advocate commissioner petition was filed to measure the suit plot wide IA number 437 of 2016, but the same was not pressed by the plaintiff for the reasons best known to him. So it is as presumed that the extent of ground is clear in accordance to the title deed of the defendant. Exhibit B1 memorandum of understanding filed by the defendant clearly shows that the plaintiff had admitted that he is unable to pay the balance sale consideration as agreed with the stipulated time, and ready to take back his advance amount of rupees 6,25,000 from the defendant along with interest from 12/12/2015 till date, and agreed to withdraw the suit. The said MOU was executed during the pendency of the suit. The plaintiff has denied his signature on the MOU as there was a forgery and fabricated and impersonation, and were obtained by the defendant forcibly. Unless contradictory is proved, the defendant cannot be non-suited at all, and the contents raised by the plaintiff place insignificant in view of the stand taken by him without any proof. There is no such proof.
What is the earnest money paid by the plaintiff?
6,25,000, my lords.
Saying there is no alternate relief.
It's not granted.
Not granted, is paid.
It was refused.
Completely it was dismissed. Admittedly it was dismissed. Suit is dismissed.
Rational kindly see take page 51. This is the cross examination of PW1. Subsequently, somebody was executed that was exhibited before the court. So cross examination respect of 51, running page 51. This was a cross examination of PW1, my cross examination.
It is recorded in the question is also recorded.
Yes, yes. The witness admitted his signature on the side by color, playing probably in the side. Narrative dated 25/7/2016, printed by me with the defendant. Whatever the terms mentioned in the are known to you or not. The witness stated at the relevant time here he was having pressure. When this court specifically asked the question, do you know the contents of a movie? Then he said, I do not know the contents. On pressure, I put my signature. This is one aspect, this is the answer given. But facts lost may kindly notice. Under this 6,25,000 was to be refunded. But that was not made. Was not acted upon even otherwise. That this is first appeal, my lord, that has to be examined afresh.
Yes, sir.
Let there be an interim order in there.
But let's have it up 2 weeks, and then I will file my counter, detailed counter along if there is any alienation or that, because my on basis of my counterpart, I can't rely my lord, because I want to contact the client also in this aspect.
Year 1 of 2023. Year 1 of 2023 is out of the meeting. See, even ordering status quo doesn't help because as per the council, it is already alienated.
Yes, ma'am.
Even further alienations can be stopped, man.
If there was
So for that, there shall be an interim. I'll order status quo only because throughout there is status. Both parties are directed to.
my lord, let them file that, because as per my instructions, my lord, there is no interim order in the pending suit, my lord.
Stated on oath, my
In
lord.
my oath, we have stated, but there is no such order has been not filed.
Password.
Okay.
Otherwise, it can be taken up.
Cannot be disputed.
Other status, let the limited status come, my lord. In the meanwhile, I will
2 weeks, sir.
problem.
I'll do one thing, wait. 28, till 28. In meantime, we can file the count. We are representing appellant. Appellants. Yes.
The appellant of the respondent claim number 1 with the deputed the appellant of claim number 3. Take it the respondent number.
Suit is decreed.
The intent of the application of sale of the 2 acres land for 1 acre into 8,75,000. That the respondent paid 5 lakhs. After that, it was paid to be paid the entire agreement same amount. For filing intentionally specific purpose. Sale is not economic very low, but allowing specific purpose.
Issue urgent notice to respondents. No stay. Short date only admission.
They are trying to
2011.
illegal construction that they are
2011.
Any short passer actually.
That's it. This 1711 PM. Item number 15. Item number 15. Morning aim. 1711. Morning, Professor. సిక్స్టీన్ అయింది కదా 112 మీరు నోట్ చేసుకోవాలి. డేట్స్ ఇచ్చిన తర్వాత మళ్ళీ అవే ఎలా పిలుస్తారు?
Kind of 1 week can maybe grant 17 and 18.
17 and 18. At request of the Kavita Yadav.
I inform.
Okay. And what about Praveen Kumar Yadav? At request of the council for the appellant in 17 and 18, posted to 23/11, both the matters.
Please, my lord, in both this appearing respondent,
Lord.
we have been trying hard.
I am representing on behalf of the essence of my member. In this,
Use mic, I can't hear you.
kindly have this matter next week, my lord. I have
Representing
placed the parties.
revision petitioner.
Yes, madam.
Nazib Khan.
My lords, the problem is
In what?
Council, I'm not able to hear your voice. Voice is not audible.
here Safiullah Beg was the standing council, my lords.
Yes.
Now, Mr. Ashutosh Joshi is the standing council. His code number is 23648.
Okay.
And name of Sophia Begum is printed. She is the senior designate, my lord. She is not appearing for work board right now. Neither Safiullah Beg nor Sophia Begum is appearing. My instructions are Mr. Ashutosh Joshi, 23648 is his code number. He is appearing for work board. His name may be printed, my lords.
Okay. Counsel for the revision petitioner is present. And Nazib Khan garu, you are representing respondent number?
One, my lords. Respond number 1, private party. I am the removed Mutawalli. My order was set aside by the work tribunal. Now they have come under revision and status quo is ordered, my lord.
Okay. Counsel for the respondent number 1 stated that Dr. Sophia Begum has
She is not the standing council now, and Mr. Safiullah Beg is also not the standing council.
okay.
Mr.
Registry is directed to verify and print the name of the standing council.
Ashutosh Joshi. Ashutosh Joshi, my lord.
To print the name of Ashutosh Joshi.
His
Standing
code,
council.
his
Standing
code-
council for Telangana State Waqf Board.
Yes, my lord. His code number also I got, my lord.
Yes.
I got it.
What number?
23648, my lord. 23648.
Yes.
Oblige, man.
Posted to first December.
Oblige.
Both the matters posted to 1 o'clock.
Oblige.
But sir. నోటీస్ ఒకసారి వెరిఫై చేయండి.
Item number 21.
Yes.
I am for the petitioner.
What about the notices, sir?
Yeah.
There are as many as 47 respondents. 47 respondents, sir. Notice and not yet returned. Proof of service not filed. When we have issued the notices, await service of notices system. Issue notices from 8, 9, 2 months. Shall we issue?
CRP file there and the order passed by the
I understood, sir. Notices have to be served first. Notices are not served yet.
Notices served, LR petition 1 of 19. I am concerned only respond number 4, 12, 13 and 29.
Okay.
Other respondents are not concerned.
Okay.
I will
But
see the order.
but notices for respondent 4, 12 not served. Even
And the notice, they are, respondents 4, 12, 13, 20, 13 died. The LRs are already on record.
12, 13 and 20.
4, 12, 13 are died.
Mm.
And LRs 5, 2, 3 are already on record.
Mm.
So my humble submission is 29 is also there, he is alive.
Mm.
No notices are served
Mm.
on the respondents LR.
Sir, you do one thing, sir. Please file proof of service. Proof of service is also not filed.
Approval filed.
Proof of service.
USSR number also is there. Approval. Yes. Fine. Also, including the account part. Yes, USSR number 19083 of 23. I also filed the bill of the acknowledgement cost expectation. File. So the LR bill should make kindly.
Yes, sir. Number ask. Yes, sir. Number. Because as per the cause list, even as per the proceeding sheet, notices are not yet served.
USSR number is file. That's it.
Anyway, 1 of 2019 is ordered or not? LR petition. 1 of 19 చూడండి ఒకసారి. అయ్యే 1 of 2019. LR petition. See, 2 petitions are pending. Council. Council, are you able to hear my voice? Is my voice audible? It's not audible. How can I communicate with you? See,
Submit my ignore.
see, 2 IAs are pending. One is LR petition. 2 is to declare minors as majors. Okay.
The picture number 9, 13 and 215.
Okay. Major declaration. See, okay. Have you filed any date of birth proof like a school, secondary school certificate or Aadhaar card or something like that? Have you filed?
Along with the picture only, they find the benefit. Age lines.
Who is the guardian?
The map 2008.
Petitioner number 3 is the guardian. Is the mother or Savitri? Savitri is the guardian. '91 date of birth is 1991.
My submission is, the order passed by the and he confirmed the order passed by the RTO only. The RTO issued passed the orders issuing the 38 certificate to various persons, including the respondent number 4, 12, 13, and 29. I am challenging only the order passed in favor of the respondent number 4, 12, 13, and 29. The page number 32. Page number 32. Second paragraph. It is admittedly one Bangur Venkaya is the protected tenant. And the respondent number 4, 12, 13, and 14 are claiming they are the shareholders and purchasers. Purchasers from the landlord. It is admitted fact that the Bangur Venkaya is a protected tenant. And in a fraudulent list, it is clearly mentioned that Bangur Venkaya is a protected tenant. Page number 80. Page number 80, Bangur Venkaya is a protected tenant of survey number so and so. It is admitted fact. And it is also mentioned in the order passed by the RTO and the RTO. Please. My submission is page number 32 may come. In Tahsildar Ramanapet in favor of the Pakiru Langanihaku and Expressa 5 years survey number 172 Pakiru. People Pahad village, they must Sukkamma, bypass or late Ramanapet, disposed of we then Tahsildar Ramanapet issue, right? Passed in favor of we is a late husband. Once in survey number 172 and extent of 5 plus 14 Punta. The Burmadi actually disposed, deposed that. Is Tahsildar Ramanapet also issued a right pass in favor of case. In survey number 176 to an extent of 37 Punta. In survey number 150, extent of 122 Punta. Survey number 180 to an extent of 121 Punta. Each year is peaceful parliament. After verification, it is very important. After verification of this right pass looks, we work on some internationally recorded as a particular and the above persons are recorded as a enjoyers and it is recorded as a purchaser. They purchased the land from landlord, Varakantam and Vilsanarity. The land purchased from the Vilsanarity, the purchasers cannot become the protected tenant. They are also not stated in the counters filed before the tribunal. Then that they have not claimed any protected tenancy rights. The page number 33 also may kindly those. Last line. Last right pass up to and he then Tahsildar. Last page number 33 in the book in the board. Tahsildar recorded classified against their names. But originally protected tenant with the registrar did not get a ownership certificate under certificate. This is very important. After verification of a filed document, they are not recorded and the protected tenants in any corner. So the respondents number 4, 12, 13 and 29 are not the protected tenants. The law says to issue 38 certificates, one must be a protected tenant. The purchaser cannot become a total tenant. The condition precedent is there to issue a 3080 certificate. They must be protected tenant. Page number, para number 27. The tenant is defined in section 2(5) of the Act. Autonomous citizen who holds the land.
Sir, where are you reading? Where you are reading, sir? You say pay.
2007 to AL, page number 20. And 21 of para number 7.
Yes. Yes.
The tenant is defined under section 2(5) of the Act. And a Assami, Sikkim, who holds the land at a local and includes a person who is a deemed to be a tenant under the provisions of the Act. Persons who are deemed to be a tenant defined in section 5 of the Act does not also state that the purchasers from the purchaser who would be a tenant within the meaning of the Act. So my humble submission is that simply they purchase the land from the landlord, they cannot become a protected tenant. When they are not protected tenants, they are not entitled for the 30 ownership certificate under section 38B. So the order passed by the RTO 1 year without issuing the 3080 certificate, ownership certificate to the petitioners of the protected tenants as per section 40. And the legal base of the Bangun Venkaya protected tenant, original protected tenant. So my humble submission is that the order passed by the RTO and which was confirmed by the joint sector is illegal and alienating provisions of the AP Tenancy and the Tenancy Act, Agricultural Lands Act.
Put it as a part. For further hearing, post it down. (2911). File written submissions.
I
2911.
I request a pass over, Your Lordship.
Shall I at 2:30 or in the meantime you want to come? At 2:30 because the other council will also have work in other courts. At 2:30.
I'm the respondent, Lash. I'm the respondent here.
You are the respondent in item number 24.
Yes.
Mohammed
Suban Basi.
Jagdishwar Reddy garu. No representation for the appellant on court. Counsel for the respondent is present and posted to. Court 12.
Obliged.
But you have to file counter on that. Counter in IS.
25 is the known law. Time for the appellant. Time for the appellant.
P. Harsha Reddy garu.
Just from the list, without R3 notices are everything. R2, beginning call is the council, standing council. R3, that is, it is not yet written. On the list as the. I think, the suit was filed for declaration and damage, that. We have
Recovery of
They
damages.
ask. They claim.
I can't get, actually it is recovery of damages 75,000. What are the future damages?
Future damage may not, they are using it, using our land.
Future damages.
So we are claiming future damage. They admit that they are in possession of our land.
Mm.
They are neither initiating land acquisition proceedings.
Mm.
I find a writ petition, my lord, for initiating land acquisition proceedings. They admit that it is my land, but they say it's something different. They admit one thing. They say it, that my lord, they are not entitled to pay. They do not say it straight away. They say that they are awaiting the result of the case. Unfortunately, they have a case. Even the matter, my lord, is the collector, is the presiding of the agency courts. He does not, he frames issues, but does not answer any of the issues. That's the problem there, my lord. Admittedly, under Order 212 rules, my lord, the judgment after a part in of once they admit it. The matter has to be heard, my lord. The R3 presence now is important in this matter. He was being set ex party in the trial court. Whether his presence is necessary or not, it is not necessary.
Proceeding sheet is only 2 pages. Proceeding sheets. When the notices are issued, should not sir. Notices. Only 1 page is there, sir. Proceeding sheet. We do not know when the notices are issued and whether notice has been issued to the respondent number 3 or not. Anyway, we'll do one thing. I'll issue fresh notice to respondent number 3. Issue fresh notice to respondent number 3 through court RP. Who is respondent number 3?
Nakapale, unofficial respondent. He did not contest to be put the trial court method. He was set ex parte. Right there. I completely did that.
But 1 minute. We do not have the entire proceeding sheet whether notices are sent or not. Issue fresh notice to respondent. Is he a necessary party?
He's not a party. Sorry.
Respondent number 3 is necessary party?
Not necessary. He was set ex parte in the trial court. He did not contest. So according to my submission, that it's not, he is not necessary belong.
Okay.
He can post it directly. No praise is sought against respondent number 3. Directly can post it for finding below the.
Then, okay. Our list is directed to post AS 402-23 under the caption final hearing. Final hearing. 23 matter then. 512, sir. 512.
Okay.
Some time because important some the last parts as on date we are paying things.
I think so there are LR applications filed by them. So I think we have to just copies, let them, I think we don't find any copies to be served. All the, let them furnish all the copies to us.
Both counsel are present from 26 to 29 item numbers. Both counsel are present.
Copies of the LR application and all the, okay.
The
Let them
counsel,
furnish.
shall I give direction to the counsel on the proceeding sheet? Shall I mention on the proceeding sheet or today itself? You are going to furnish the copies today?
Yes, today furnish.
Okay.
At request of the counsel for the revision petition.
Our 10 days lodging may post it.
Post it to 21.
Much.
You are the appellant and also petitioner in the condon delay petition you have filed. Okay. Mr. Yuvraj, counsel for, sorry, your name is already written 2 times. Indrasena Reddy garu. How many days delay? 230. Manu, records call. Records. No aim result. No representation for the respondent call. Counsel for the appellant is present. Counsel for the respondent. First time, like this time. For filing counter. For filing counter in IA 1 of 2014 by the counsel for the respondent as a last chance. Posted to. No. Not on the preceding sheet. And in the meantime, await LC records. Await LC records. Posted to 20 to 11. Record of it. 20 to 11. 20 to 11. See, LC records are awaited. We have not received LC records. And furthermore, for counter in IA 1 of 2014 condone delay petition as a last chance posted to 20 to 11. Next. No representation either side on call. Hence posted to 512.
My sir is coming online.
You are representing?
The permission petition, madam, to extend, madam, we have money.
It is item number 32.
32, madam.
Yes, my lord. I am appearing this matter, my lord. I am appearing this matter, my lord.
My lord, item number 32, my lord, I am appearing for respondents 3 to 6, my lord.
Yes. But I filed this application.
Item 32.
Okay, this application, my lord, is filed for extension of time.
Sir, I can't see you, Janardhan garu. Janardhan Rao garu.
Yes, my lord. But my word. You will
Your-
have to be able to hear my voice.
Your video is in the opposite direction.
Yes, sir.
Sir, senior, sir.
Now, my lord. Yes, my lord. Now your lordships are seeing.
Now I can't see you.
Anyhow, my lord, my video is some problem with my car.
Last audio.
Audio, your lordships are able to hear. My lord. Your lordships are able to hear my audio, my lord.
Yes.
Yes, my lord. Lord, this application, Lord, is filed for extension of time, Lord, in depositing the suit cost, Lord. The appellant, Lord, filed the appeal with a petition to condone the delay. Lord, they are 16/8, Lord, this honorable court, while condone the delay in filing the appeal, but directed me, Lord, to deposit the cost in 4 weeks. Lord, costs are heavy, Lord, could not deposit, Lord. Poor lady, Lord. Now, Lord, when she went to deposit the cost, Lord, unnecessarily, Lord, bank court will not take, Lord, unless after time is expired. Therefore, Lord, she is seeking time, Lord. Yet 1 week time may be granted, Lord, so that, Lord, she will deposit the matter cost. Because it's a very suit for declaration of title and for recovery of possession was dismissed. The main appeal, Lord, is pending. Lord, for just because for want of cost, Lord, deposit. She will deposit, Lord, by 30th or 14th.
My lord, in this matter, my lord, I am appearing for respondent 3 to 6. My lord, your lordship may kindly see the order, my lord, dated 16th August 2023. My lord, while condoning the delay, my lord, this honorable court, my lord, specifically directed the appellant, my lord, to deposit the suit cost within a period of 4 weeks from that day, from 16th August 2023, my lord. So the time granted by this honorable court expires on 13/9/2023. But he is leisurely coming up and filing this application.
Hmm.
IA 1 of 2023, my lord, on 6/11/2023. My lord, seeking a direction from this honorable court to extend the time by 10/11/2023, my lord.
Yes.
But I have no objection, my lord, if the time is granted by this honorable court. My lord, this honorable court, my lord, Her Lordship Justice Radharani Garu specifically directed, while condoning the delay, directed him to deposit within a period of 4 weeks from that date, 16th August 2023. Already, my lord, the time granted by this honorable court expires on 13/9/2023.
But that is true, my lord. That is true, my lord.
He has
Even
not paid
in
the
the
suit
petition,
cost
she
within time.
my lord, even in the
And the
petition,
extension application also is not served on us. My lord, I have no objection, my lord. If my learned friend, my lord, wants time till 10/11/2023.
Yes, my lord, 10/11, my lord, by 10/11.
Your lordship may kindly see the prayer portion, my lord.
Yes, that's
For a moment, your lordship kindly see the prayer portion. IA
I'm
2 of
accepting
23.
I'm accepting, my lord. I have sought for time only up to
He is seeking
10/11.
time till 10/11/2023. That is still Friday, my lord.
Yes. If the order copy gives it today, my lord, tomorrow itself, my lord, we will deposit the amount.
My lord, your lordship may order that application, my lord. We have no objection. But your lordship may put a rider on that, my lord, default clause. In case by 10/11/2023, if he fails to deposit the suit costs, the my lord, order passed by this honorable court stands vacated.
No.
IA may be dismissed, my lord. Condone delay application. That is IA 1 of 2019.
No problem. We will deposit it, my lord. Order copy may be furnished, my lord, today itself. Tomorrow you will go to the bank, my lord, for trial court and deposit the costs.
Copy for today, my lord.
ఏమైంది మా కేసు ఏమైంది
10/11.
Hopeless, my lord.
My lord, in case, my lord, if you deposit the suit cost, my lord, liberty may be granted to withdraw liberty may be granted, my lord, to withdraw the suit cost, my lord. In fact, the decree also specifically
implied, sir.
says
It is
suit cost to
implied.
be,
It is implied.
my lord, suit cost to be paid only on difference 3 to 6. That is response to 3 to 6 year in, my lord.
As per the decree, as per the court direction, we will deposit the cost.
My lord, your lordship may say, my lord, I am permitted to withdraw that amount in case if you deposit the suit cost, my lord. Your lordship may, my lord, Usual order, my lord, your lordship may
See,
observe that.
whether the same is mentioned in the IA 1, that is 1 of 23 or something.
No. Suit deposit cost may be deposited within 4 weeks. That was the direction.
Okay, and it is implied. See, once the amount is deposited, it is implied. It can be withdrawn.
But my lord, your lordship may observe
The
that.
order, see, that order is not passed by this court.
That's true. Yes, my lord.
It's implied, sir. There's no ambiguity.
Much obliged.
Next. 1011. Yes. You are the appellant? Appellant. Condon delay, how many days delay? That application is filed by the appellant herein? Is filed by the appellant herein? Is the condon delay petition is filed by the appellant herein or by the respondents? Because there are two As. Two appeals are there. 226 and 93. So how many days delay? 500. So are you going to file counter? Counsel? For the respondent? Are you going to file counter in condon delay petition or not, you tell me? Or shall I order the IA? Both counsel are present for filing counter in IA 2 of 2023. Posted to 30. 11. 30.
The suit for deliberation and architecture in nature.
Hmm.
In the suit, we have already have a
Prabhakar.
nation prior to filing the suit.
Hmm.
We have filed the then petition also for injunction of it.
Hmm. Notices are already served. A. Prabhakar Rao garu. Notices are served. Then I'll post it as final hearing. Why is still in interlocutory this is posted?
Maybe. In the meantime, I am around.
Which IA?
Yes, there is an IA.
Injunction petition.
The suit for deliberation and architecture injunction.
Counsel for the appellant is present. No representation for the respondent at call. We'll see whether they will file any counter or not. Posted to. Please come. Posted to 6th December.
Meanwhile, department will call for us.
This is directed to call for the records from the concerned court.
Finally, 36, we go call the
I'm appearing for the first respondent in this. Last time, notice has been ordered. I have stated last time also that the third respondent is not appearing.
LC records received in this matter? Not received.
It's an amount of a payment of 62,000 odd rupees, your lordship. But here, the first respondent husband met with accident and died. And the compensation was awarded. They deposited one.
Counselor present.
Gopal Das sir present.
Shall I pass out the matter, ma? I'll pass out. We'll see whether the counsel will appear or not.
Your lordship kindly see third respondent. He never appeared before the lower court and also in a CMA earlier they filed one CMA that was dismissed. In that CMA also he has not appeared. Third respondent Habib and company. He never prosecuted any case. So in the notice always only indicating that it is returned unserved like that. And fourth respondent is not also his formal party because yet the ownership is not transferred into the fourth respondent. He wants to purchase the car, but the ownership is not transferred.
Already manam dismissal caption pettam.
Yes, your lordship. Afterwards, it is so many times it has
no representation for the appellant and call. As the cases of the year 2006. It is posted under the caption for dismissal. 2006 matter is still there.
And number of times it has come under caption dismissal, but your lordship notice not served. Again notice, again also after that your lordship has ordered the notice 3-4 times.
Monday, Tuesday, 14/11.
Obliged.
Under the caption for dismissal.
Notice is ordered. And it's out on both the respondents.
Okay.
R2.1.
So Manjula Gar is there. She's in
It's
virtual.
not the time.
Yes, you are ready with the argument, sir? Next week. Counsel for the appellant is present. Counsel for respondent number 2 appeared through hybrid mode. At request of the counsel for the appellant posted to 16/11.
Obliged.
But the appellate counsel is seeking time allowed.
Counsel for the appellant is present at request posted to 30:30.
Obliged.
For respondent 1 and 2, my lord.
No representation for the appellant on call. Posted to 1st December.
40.
Appeal filed by claimants, Miller. I am respondent number 2, Miller. We are the respondent. Case of injuries, Miller.
Why Ajay Shravan Kumar Garu is not
Venkatram Reddy, I am.
I know Ajay Shravan Kumar Garu is not appearing. చాలా రోజు రావట్లేదు.
What?
No representation for the appellant on call. ఇది కూడా dismissal caption పెట్టండి లేకపోతే ఆర్డర్స్ పెడదాం లేకపోతే applicants have filed the appeal. I'll post it under the caption for orders. Orders పెట్టండి. Orders posted to 24/11.
41. People set of rating. People allocation.
These appeals are filed against the endowment tribunal, order passed by the endowment tribunal, declaring the petitioner's appellants herein as an encroacher. Interim orders have been obtained and they are not coming forward.
No representation.
Last time they represented Malad that they will argue the matter next week. This day, Malad.
There is no interim stay also. Interim stay is not extended. Yes.
Yes, ma'am.
Yes. Counsel for the appellant, both counsel for the
41, 42 and 43 it seems.
counsel for the appellant and GP for arbitration are present. At request of the counsel for the appellants posted to 4/12. See, there are no interim stay. It's not extended. Bear in mind. 4/12.
Obliged.
In 44.
Respondent.
Here.
And for respondent.
Respondent. No representation for the appellant on call. No representation for the appellant. Counsel for the respondent is present. Hence posted to 5/12.
45, 46 and 47.
Both counsel for the appellant and GP for arbitration are present at request of the counsel for the appellant posted to 512.
Apply.
48, 49, 50. No representation for the appellant on posted to 512.
I'm for the appellant representing so much Venkatesh.
Like, please, time for the respondent.
It's insurance company appeal. Case of injury. Claimed 5 lakhs and awarded 3 lakhs 7,619. We are challenging the disability part in this.
What is the disability assessed by the
Lordship,
doctor?
As per para number 6, my lord,
Hmm.
the doctor he has not treated him, my lord. He has only gave the opinion based on the record, my lord. Para number 6, my lord. Dr. S. Vasudeva Rao, an orthopedic surgeon, was examined as AW2 on behalf of the applicant. In his evidence, AW said he is working as civil surgeon specialist orthopedic surgeon in King Koti Government Hospital and practicing in Konark Diagnostic Center, Tilshungar in the evenings. He said that he knew the applicant, Mr. Shekhar, as patient. He said that patient came to his clinic on so and so date for obtaining disability certificate. He said that he examined the applicant clinically and radiology and found that the applicant was having old dislocation of right hip joint, which was reduced and communicated fracture lower 1/3 tibia with interlocking nailing in stew. Fracture is united with a mild restriction of ankle and knee movements. He said that he has assessed the disability as 30%, which is permanent and partial, basing on MC Bridge scale, and also assessed loss of income capacity at 60% as clean. He said that it is difficult for the applicant to sit and squat and walk for long distance, and that one more surgery is required for removal implants. And my lord, in para number 7, last line, my lord, I mean, internal page 5. Internal page 5, last 4 lines, my lord. He accepted that he has not mentioned in Exhibit A12 that the applicant cannot sit and squat and walk for long distances. He accepted that the fracture has united. He denied that he was deposing false to the applicant. My lord, he has assessed the income loss of earning capacity as 60%, my lord, for 30% disability. And the other part, my lord, the age of the disease is taken as 20. Sorry, the age of injured has taken as 20, my lord, whereas he has not filed any document to prove his age, my lord. It is only taken on the basis of Exhibit A5 and A9, my lord, which is certified copy of wound certificate and medical certificate of SCS Medical College, whereas the injured has studied 10th class, my lord. He was working as a cleaner, my lord.
I will slide. Yes, yes. Counsel for the respondent.
My lord, insofar as the disability is concerned, my lord, disability has been rightly taken, my lord, 30%. Loss of earning capacity 60. Your lordship will see that he is a cleaner by profession, my lord. He was. By the time of accident, he was 18 years. My lord, there are 20 years was taken, my lord. Insofar as the documents, medical record exhibit A5, A9, well, that goes that not the age of the injured, the claimant is 20 years. But the disability is permanent and partial. That is what is held by the doctor. But the judgment of the trial court is proper. There is, in fact, nothing brought on the record by the insurance company. Your lordship will see the percentage. The only claim is with regard to the disability. The disability was assessed at 30%.
That is what. See, doctor has assessed 30% disability and
Yes.
also stated that he has only a restricted movement
Yes.
related with mild restricted movement.
Yes.
And the tribunal has taken 60% disability.
Yes, my lord. Because loss of earning capacity.
Loss of earning capacity is okay. 60% of earning capacity is okay. But disability assessed by the doctor is only 30%, whereas the tribunal has taken 60%. Despite evidence stating that it will be only mild restriction
No,
movement.
no, it is not mild. Your lordship will see. Found that the
On the
applicant
record,
was having
record.
old dislocation of right hip joint, which was reduced and commuted lower fracture 1/3 tibia with interlocking nail institute. Fracture has united with mild restriction of ankle and knee movement. He said that he has assessed the debility of sensor. Said that it is difficult for the applicant to sit and squat and walk for the long distance, and one more surgery is required for removing the implants. But here is the case, he is a cleaner. Your lordship will also consider the job of the cleaner. But in that circumstances,
I'll slightly reduce the disability from 60 to 50.
one submission I make and leave it to your lordship. Your lordship will consider that it's a beneficiary legislation.
I understood, sir, but
Yes,
at the
madam, I'll
same
leave it
time,
to-
see,
I'll
we
leave it to-
cannot go beyond the doctor's evidence. No,
Yes,
why the applicants will examine the doctor?
Yes.
He is the right person to assess the disability, not the court. And he has personally examined the applicant and assessed the disability. Though he's not a doctor who has treated, but
Yes.
he can assess the disability
Yes,
based
ma'am.
on the records. He has done that, but I feel it is slightly on higher side.
I very well.
5%, 55%.
Yes.
That's 5% reduce. Just ఒక్కటే మారుద్దాం. So Ranjimanandi. Yeah. Appeal is partly allowed. I reduced from 60% to 55%.
Much obliged.
Respond number 1 to 3.
Your respondent number 1 to 3. Yes. G. Ramasharma garu. No representation.
On last occasion, my lord informed
Hmm.
if they don't turn up, my lord will dismiss the CMA. This is the 8th adjournment they are seeking.
No representation for the. Okay. What is this? Okay. But is that?
In fact, there is a suit that is been filed after this.
If this is an arbitration case.
Yes, arbitration, my lord. My lordship. If my lord permits, I will submit.
Okay.
To submission.
I'll put it under the caption for dismissal. No representation for the appellant on call. In spite of opportunity given and number dates notice. In spite of opportunity given, the appellant has not submitted arguments on so and so dates. As the cases of the year 2011, it is posted under the caption for dismissal. Call on 1511. 1511. If they do not turn up, I'll dismiss.
Okay.
Otherwise, I'll pass on. Next.
We are for respondent, my lords. We submit. So workman comes.
ఇది కూడా అంతే అప్లెంట్స్ WCKs.
My lordship, I'm appearing for counsel for appellant. He met with an accident. He is unwell.
Who?
Counsel for appellant.
Counsel for the appellant.
Ravi
Kumar Gara met with accident. When?
April, May. He's unconscious.
You are junior counsel for Ravi Kumar? You submit your arguments, I'll assist you. It's only insurance company.
Insurance company.
1 week this time.
2 weeks.
Why 2 weeks? Both counsel are present. Junior counsel పేరు రాసుకోండి ఆయన లేరు కదా. B. Vijay Kumar, junior counsel for Ravi Kumar, has stated that his senior met with an accident and is in coma. Hence, at request, counsel for respondent is present, hence at request posted.
1 week, my lords.
1711. 17. No representation for respondent. Counsel for the appellant is present. At request of the counsel for the appellant posted to 1711. అది కూడా సేమ్
I'm appearing for the respondent number 2 insurance.
Counsel for the respondent is present. No representation for the appellant on call. Achud, how many adjournments they have taken? Old matter. Posted to 30.
Bless.
No representation is said on call, hence posted to 1st December. అది ఇందాక అడిగారు 2111.
51. Valamon Reddy, taken Yoga Prasad.
In the previous station, connected matters were listed there. Notice was ordered in those matters. Around 20 matters were listed really close to the last month. Finally, a notice was ordered to the respondent because no one was available. But the only issue is lordship, it's an arbitration application in the lower court of the year 2012. And after that, that got dismissed and a CMA has been filed. But we are not able to get in touch with the clients with regards to whether arbitration.
I went to find. So you say that there are other cases connected with these three matters.
Other than these three matters, there are around 20 other matters which were listed during the course of the last 2 months.
They are all connected, huh?
Same parties and all. Arbitration applications in the lower court were dismissed. So a CMA has been filed.
Can you furnish those numbers, Amma?
Maybe post tomorrow or after I'll get all the details.
So that see what will happen is sometimes these cases connected matters will be posted in another court. The difference of opinions will be there now.
I'll just furnish
So that counsel for the appellant is present. Amma pair raskondi. Is present and stated that there are other connected matters are pending, and for furnishing all those numbers she requested time.
Also seek instructions and all that lordship 2 weeks will be given.
23 minutes.
Opening for the respondent number 1 minute.
And one big right.
Why? Huh? What is this CMA?
CMA has been previously ordered dated 21 January 2012, allowing petition under section 372 of Indian Succession Act.
I personally feel that this CMA has become infructuous. Isn't it?
That week time allows will get instructions and also if required will produce.
So they have filed this in the year 2000.
It is with regard to the debt benefits of the.
I understood. But how many years they'll take?
2 minutes.
After 20 years. What happened to the parties?
And there is an interim stay, it seems, minutes in the.
The party shouldn't suffer.
Get instructions, my lord.
There's only a short point, minutes, whether the marriage of the second respondent, the respondent appellant before your lordships. The ground is that minutes I took the customary divorce from the deceased. And that was not proved before the court below. Therefore, the OP was allowed minutes. Customary divorce, they did not.
Proof of customary divorce means they should belong to certain community. Then only that can be accepted.
Certain community, and they have filed one exhibit minutes. There was no signature of the husband. And admittedly, minute the the respondent number 1 before your lordships is an illiterate. She puts thumb impression, and it was written as the customary divorce Mallamma. So, considering all these factors, your lordships, the court below came to a conclusion that the marriage was subsisting between the deceased and the respondent number 1. Therefore, minutes the OP was allowed.
They belong to some tribal.
Rajaka. They belong to, admittedly, they belong to.
Rajaka, it's not, there is no such.
Assuming without admitting that minute.
Only in tribals it will be.
Yes.
That you have to prove.
But all that I'm requesting is only for a week time allows. Can we get instructions? We'll also, if required, will submit on marriage.
Okay. But come with proper evidence. Okay. We need that the community certificate also in case
Yes, sir. In fact,
they plead for customary divorce and all.
Court below clearly stated in paragraph number 17, your lordship, it elaborately discussed.
Both counsel are present. At request of the counsel, posted to how many days you need? Week is okay. 2311.
In 65, if above,
May I please your lordship. In this, I am representing the appellant. I request 2 weeks time, my lord.
For the respondent.
What is it? CMA?
Yes, sir.
Yes, I am.
Yes. How many adjournments they have taken?
You said last time, my lord, my friend took. This time I took. Second time, next time we will do it. Because requires to for understanding, my lord, becoming difficult.
But sir, these are all old matters we need to dispose of.
Yes,
That
ma'am.
easy cases means.
Your lordship is right. Or next week, your lordship, please.
Okay.
Next week
What
means
counts?
holidays are there.
Counsel for
2 weeks,
the
your lordship.
counsel for the appellant appears through hybrid mode. Counsel for the respondent is present. At request of the counsel for the appellant posted to 17.
Yes.
1711. Get ready on the disk. Both of you.
Very well.
Oblige.
My lord, I am for the respondent, my lord.
You are representing?
Respondent, my lord. Claim is 3
No.
lakhs, award is 1,13,000.
Representation for the appellant and call.
Is a matter, a respondent before lordship is admitted in the hospital with a condition is very serious, my lord.
I posted for orders then.
Yes, my lord. The accident occurred in 99, my lord, the 25 years, my lord. Already.
You do one thing, submit your arguments and put it as part.
Yes, yes, my lord. Okay. The accident took place on 22/1999, my lord. Before the police registered a case in crime number 23 and on behalf of the appellant, my lord, exhibit A for the respondent, exhibit A1 to A8 marked, my lord. The claim is 3 lakhs, my lord. Award was granted 1,13,736, my lord, and given the 40% disability, my lord. Exhibit A1 is the fair, my lord. Exhibit A2 is the charge sheet, and exhibit A3 is the Xerox copy of insurance policy, page number 7 in the matter papers, my lord. And also file the driving license, copy of the permit. At the time of accident, my lord is driving the
Banu Prakashkar is also there. Your case only.
66.
Order. B. 14. Page 14.
Yes.
Therefore, the respondent is directed to deposit by way of demand draft
of the Commissioner for Workmen's Compensation and Deputy Commissioner of Labor under the HIGCOURT. So it's at 12%, amounting to rupees 40,944.96. And penalty of 50% amounting to 56,860. And the virtual amount, the data are passed on 2025. The total amount of rupees 1,13,000. Just 12%. That's a penalty of 50%. That's 2,07,000. Penalty will have 12%, 2%.
Only on that you have preferred the appeal, eh? Penalty. Okay.
Round number 3, 4, 5. Like we kind of see the startup is contrary to law. Compensation is against the compensation. Law compensation. Now number 3, the commissioner grossly erred in making the appellant liable to pay an amount of rupees 40,000 and 44 and respect towards interest. The authority ought not to have ordered is the against the act workman compensation. The authority will not give it the direct to pay interest.
No penalty as especially.
Interest were influenced by its not 14.5. The commissioner awarded interest at 6% per annum payable after 30 days. This has to be done. Fifth, the commissioner grossly erred in making the appellant liable to pay penalty at 50%. This is also is the act. It's 3, 4, 5 method.
Only on those aspects will take. Sorry.
Deeply blessed. Yes.
Ramul garu. No representation for the appellant on call. Counsel for the respondent is present. It's posted to 112. Malleswara garu.
Yes,
Okay,
Your Honor. Your Honor, kindly adjourn the matter, Your Honor. I am held up in traffic, Your Honor.
Anyway, we are in 69, item number 69. No representation for the appellant on call. Hence posted to 112. Next.
70.
T. Damodar and B. Kavita Yadav. Councils who are online, please try to switch off your mics. Causing disturbance to the court.
In this matter, my lord, I do not have papers. I have to collect it from the other side. The case is allotted.
This
to
one,
me.
Amma, Kavita, yes.
70.
Item number 70.
Just the advocate, he said that he would serve papers on me because this has been allotted.
Shall I give direction to the council?
Yes, my lord.
Council
So
for
they-
the respondent
along
is
with the lower
present.
court record.
No representation for the appellant on call. Counsel for the appellant is directed to serve the copies to the respondent counsel. Posted to 23.
Obliged.
Actually, what happened was he has given up the wakalatama.
G. Damodar.
Then
the notice has to go to
there is
party.
a note by the registry stating that memo filed by the counsel for the appellant and yes sir number and other things have been furnished informing that he has given up the wakalat.
Then the notice should go to party.
Again.
Yes, madam. Your lordship, my direct mother.
The note also we can registry. So find out. As the counsel for the appellant has given up the wakalat, issue notice to appellants. March and step.
Same date, my lord, 23/11.
23 Sarputunda.
it won't.
Hyderabad. Let us
Yes.
the month ending.
Month end, yes.
30 levels.
Even 71 came out, you was not the right. Yes.
Yes.
Case of injury where additional one compensation. Claim around 6 lakhs, committed avoided 5 lakhs, 15,000, 605. Mainly, but insurance company disputed its liability not. Insurance company disputed at that time, instead not. Accident occurred and the driver's name mentioned on the note. The insured owner also filed another claim that is damage of vehicle. That is the OD claim. That OD claim will not mentioned at the time of accident that is the driver is R. Satyanarayana. But in the OD claim, they stated the driver name Bal Shetty. The two different persons. On that count, Millard. This claim Millard driver is so and so. But OD claim they claim damages of vehicle. In that claim Millard mentioned the driver at that time Bal Shetty. On that count Millard insurance company disputed its liability. Only a main ground Millard that is. Insurance company accused the evidence Millard. Moral evidence and also documentary evidence that is the exhibit B6, B7 and B8 Millard. That is related to OD claim documents Millard. And OD claim copy I am having one copy Millard is the OD claim form. In that form also Millard the driver's name OD claim Millard showing driver's name R. Satyanarayana. But in the present WC claim Milord, Milord related fair and Milord. You know what one the driver's name Balset. But Milord, the exhibit is related to what is claim claim form. Exhibit D7 Milord. D8. D7 Milord, the body claim copy, the column driver's column Milord. The driver details. The name of the driver and section. That body claim copy Milord. 5 Milord, the insured stated. మా మిత్రుడు అయిన సత్యనారాయణ తన పని మీద కారు తీసుకుని హైదరాబాద్ నుండి కరీంనగర్ వెళ్తుండగా మార్గ మధ్యంలో ప్రజ్ఞాపూర్ దగ్గర వచ్చేసరికి ఎదురుగా తీసే అతివేగం అజాగ్రత్తగా నడుపుతూ ఢీకొట్టింది. ఆ సమయంలో కారు మాట్లాడితే ముఖ్యంగా అతని సోదరుని ముగ్గురి గాయం జరిగింది. అందుకని దయచేసి క్లెయిమ్ ఇప్పించగలరు. ద కాలం నంబర్ 7 డ్రైవర్ డీటెయిల్స్. ద డ్రైవర్ సత్యనారాయణ. But in the present WC case may not file against this appeal. In the present case, claimant of compensation, the injuries received by one R. Pal Shetty showing as the driver of this vehicle. Both are different persons. But the insured given showing in the WC case, driver Pal Shetty, but in the OD claim, vehicles damage claim are such an R. And the two different statements, not insurance company, it's like. And also, Milord, in the present case, the disability doctor stated 30%. The conditioner taken into consideration needs Milord 60%. And this full count Milord, the present topic file.
But that plea was not taken in the written statement regarding OD. మనకి రికార్డ్ కూడా లేదు. No, in the written statement, have you mentioned that OD, the driver name is different? The driver is different in OD claim, and the driver in this application is different because the accident arises out of the both OD and the claim application. Both the cases are not filed at the same time.
OD filed Milord dated 14/7/2011. OD claim filed before insurance company 14/7/2011. WC in the year of 2012.
Taken into the external component, but balance 60.
And driving license of the driver is also filed. Driving license under Exhibit B5 is Mr. R. Satyanarayana. Submitted by the opposite party one. Driver is
driving license.
driving license of the driver. Balasetti.
Yes, ma'am.
Huh? Balasetti.
WC case, the claim was related to Balsi.
And the insurance company has filed Expert B5 driving license. Shows the driver as Sachinarayana. And Expert 812 మనకి రికార్డ్ వస్తే బెటర్ ఏమో. I'll call for the record because even the claimants have filed driving license of the driver under Expert 812. Let us see whether Expert 812 and Expert B5 are one and the same or not. 812 and B5. Then we'll have some clarity. Because you say that the driver mentioned in OD is different and the driver in claim petition is different. It might be. And these kind of cases have to be dealt together actually.
Different statements made by the insured, well, that is the difficulty. So one is for WC compensation at the time filing a OD claim for damage of vehicle showing another person. These two different statements. Who is the actual driver?
Pending was given by the commissioner at page 28.
Page 28.
But insured's own statement lagged by insured. This OD claim lagged by insured.
That they have to take steps against the person who has, he is the person who has driven the vehicle, and the police record also shows that he is the person who was involved. And also the record shows that the owner has given the statement that the claimant is the one driver of the vehicle.
And the medical record will be there. See, I think there will not be any dispute regarding the accident and also injuries.
Yes.
Even if they planned some other person, he might not be an injured person.
Yes, madam.
Maybe some mistake, maybe. I'll call for this. Both counsel are present. Registrar is directed to call for the record from the consent court immediately. 3011. 3011. No representation is said on call, hence posted to 29.
73.
You are ready. My parenting? What is it?
Akhilesh.
Akhilesh.
Yes.
No representation for the
Let me post it on Friday. Friday.
No representation for the appellant on call. Counsel for the respondent is present. Hence posted to 2017. Yes? Posted to 1411. We are in 73, item number 73. 1411. 1411.
14. Lordship might call for records if that records are
What's here? Available.
much obliged.
70 for 3 years now. It's the one.
Lordship, may kindly tomorrow, my lordship, I am just out of session, my lordship. Kindly tomorrow, my physically hearing, my lord, tomorrow, my lord, I have out of session, my lordship, kindly.
Okay. 811.
Oblige, my lordship. Oblige, my lordship.
No representation either side on call. Hence posted to 412.
76.
75, I'm for respondent, my lord. 75, I'm for respondent. It is with regard to partition. As per the pleadings in the plaint, partition, oral partitions was already effected. And in view of that, the suit was dismissed.
I am for the appellant. Lordships kindly, I am appearing for the appellant.
Sir, I'm calling the council name, but there's no response. 75, both council are appearing through hybrid mode.
Yes.
So both council are ready with the
Yes.
arguments in AS 39 of 2019?
Yes.
Servant.
May please start.
Suit is filed for partition and separate position.
Suit is filed by the daughter, partition and separate position of undivided 1/5 share of the plaint of the suit schedule property. The admitted case is that she has been given 4 acres of land towards Pasupu Kunkuma. The case of the plaintiff is that this land, though given to her as a gift at the time of marriage towards Pasupu Kunkuma, has not been delivered to her in as much as the same was in the custody of respondents 1 and 2 who were managing the property, and they were giving her share to her out of the yield. When they stopped giving her share, she filed the present suit for partition. That is the case in short of the plaintiff. Now, my lord, if your lordship takes the defense set up by the defendants, is that they have given 3 acres towards Pasupu Kunkuma, and this 3 acres of land was sold by the plaintiff to her son, son of defendant number 2, about 18 years back, for which, my lords, there is no proof. It was an oral assertion made by the defendants that the plaintiff sold this land to defendant number 2's son. There is no proof about it.
Yes.
No, my lord, the plaintiff, the court below mainly goes upon the fact that this property was, though given to her as Pasupu Kunkuma gift, it was sold by her without there being any proof to show that this property was sold. The court below framed 2 issues at para 4 of the judgment of the court below, whether the plaintiff is entitled for 1/5 share of the suit schedule property and whether the plaintiff is entitled for preliminary decree for partition and to what relief. Both the issues were held against the plaintiff only on the premise, taking into consideration the evidence of the defendants, which is not supported by any documentary evidence at all to show that this property was sold. And the court says that instead of a suit for partition, the plaintiff ought to have filed a suit for declaration and recovery of possession, which is contrary to the very pleadings of the plaintiff, as well as the evidence, the written statement filed by the defendant. They said, we have already given that property to her and she sold it. And there is no proof that she sold it. No documentary evidence filed, semblance of documentary evidence, or any oral evidence to show that she sold the property.
Yes.
Therefore, my lord, she will be entitled to that 1/5 share which she is claiming. If not 1/5 of the total amount, total suit schedule property, at least 4 acres of land, which according to her was given to her at the time of her wedding. If your lordship takes up the written statement of the defendants 1 and 2, that is the mother and brother.
We do not have the record. Shall we call for the record?
In fact, my lords, I have prepared paper books which are
Paper book.
Paper book, I have not received paper book. But however, the low court below, categorically held that oral partition was effected, and insofar as 4 acres is concerned, which falls to the share of the plaintiff, she used it to get the.
Not completed my arguments. Why does my friend begin his argument?
No. It's best.
Please.
Court asked.
No, this is not correct.
No. Court want to
Completed my
case. That's why
argument.
court want to adjourn the case. That's why I
Please. No. Court only wanted to know whether the records are ready or not.
Yes.
We have not received the LC records, and furthermore, no paper book is available in the record.
I have also not received. I have also not received paper book.
Lordship may have it day after tomorrow. I will provide paper books to both my friend and to the honorable court.
Day after tomorrow, instead of day after tomorrow, 14th.
14th. Both the council appeared to hybrid posted to 14/11.
That paper book it may be recorded.
For filing. Paper book posted to. Next.
76. Kindly have it next week. 15th of November.
9th or 18th?
18th will be taken. 18th of November.
18th is Saturday. Why council?
20th. Sorry.
Okay, 20.
Entry model will extend.
The interim orders. Okay. Extended till then.
Until further orders, it is being extended. Published in that.
SAV Ratnam garu.
May it please, Your Honor, I am for the respondent, Your Honor. I held up in traffic. Kindly adjourn or.
Okay.
Actually, this honorable court had the both sides in the last occasion.
Even fine.
Lordships had the revision. Last occasion, Lordship.
Let me verify.
Let me verify. Remand of the matter. Both of us agreed for remand of the matter.
Is it Mallisra garu?
Yes, Your Honor. I am held up in traffic, Your Honor. That's why requested to adjourn or.
1 minute, Ratnam garu. Please wait. Mallisra garu. SAV Ratnam garu says that the matter has to be remanded without going into the merits. Is it true?
But I am requested this honorable court to remand back to trial court, Your Honor.
Trial court, and I remember that. Okay, I will.
Your lordship posted for others. What I submit that Millard, the appellate court's order, I am challenging that the appellate court did not consider the Millard additional evidence filed by me.
Kindly adjourn or pass over, Your Honor. I may be permitted to argue the matter.
Okay,
I leave it to your lordship. I leave it to your lordship.
tomorrow or Friday?
Okay, okay, Your Honor.
Millard,
10,
instead of
11?
Millard 14th Millard instead of.
Okay, 14-11.
Yes, Millard.
No, 14-11 is not possible, Your Honor. I'm out of station. Tomorrow it may be, or pass over today itself.
Tomorrow there is function in my house.
Or post after 2 weeks.
Your lordship may extend the stay at Millard post after. The only Millard, my only submission is that Millard, I challenged the appellate court.
I understood, madam. I understood and I remember that. I could
Yes,
recollect.
yes.
2011.
Pass over, Your Honor. After lunch, I may be permitted to.
Okay, come.
Otherwise, your lordship may pass or Millard, I have no objection.
No.
Better your lordship may pass.
Pass or yes. Yes, next.
Okay, Your Honor.
78. Speed off.
No, counsel for the appellant appeared in the morning. No representation was responded. Posted to 1st December.
Respondent later. Okay, sir. Yes. Okay. Okay. None represented for respondent number 2. Learned assistant public prosecutor is in attendance at request for continuation of further arguments. It's a matter on 20th.
The sister-in-law in Number 6.
Answer making. And item?
6.
Answer understand కదా.
Number 14. It is Satish Babu. The appeal has been prepared and reviewed by the other half in the year of state. Where in the HIGHCOURT case you have to petitioner before not to pay. Plaintiff in the 2 keys for declaration of title and we have the intention. Then you have the defendants, the respondent hearing filed, we have the IA, Order 7, Rule 11, the rejection of this date. On the ground of Virat 15 barred violence. That was allowed Virat. By this, Virat, now Virat, the petitioner before that, your lordship, once Virat, your lordship, one suit has been numbered. But that has to be decided only Virat after filing a written statement, Virat by contesting the matter, whether the limitation to the cause of act. But Virat, here, Virat, the IA, which was allowed Virat rejecting our claim. But without any reason, your lordship may say, take the include the finding of the trial court. Page number 16, you know. Whereas, review of the availment perfect, seen the petitioner different number of seeking to declare the document number personal. And by using the document, it is seen that said document was included by the finance respondent plaintiff in 1983 during the entire lifetime. He never raised any issue dispute claiming that alleged regard to sale date manipulated or fake document deadly stage after laptop so nearly 40 years the respondent cannot allow to dispute the document which their father has never done. Further, the suit is badly barred by legislation. The cause of action to file a sudden suit cannot be considered to be a genuine as the same was not disputed by the father himself who had executed shared alleged sale. Because further continued that father died 2019, so even during the lifetime of the father of the respondent plaintiff till 2009. The father raised no single dispute alleging that said sale deed is a fake or forged document. So now after this, the respondent plaintiff cannot maintain the suit after 40 years. Further, in view of the judgment on the Supreme Court filed by the petitioner defendant discussed Rego reported for instance. This court inclined to allow the petition finds that filing the suit is nothing but abuse of process. The lordship aware once if it is the suit is not within a limitation. Generally, the section will not be numbered. Once the section numbered, put as came before the trial court. That has to be decided only after filing a written statement, full-fledged trial. But the scope of the Order 6, Rule 11, and 3 grounds I extracted my counter. Page number 44. In respect of the averment made in the affidavit, paragraph 6, under heading Order 7, Rule 11, rejection of claim. The claim shall be rejected in the following cases. Order 7, Rule 11, where it does not disclose a cause of action. Order 7, Rule 11D, where the suit appears from the statement in place barred by any law. If further submitted Order 11, Rule A, B, C, rules applicable, there is place to fail to prove the essential ingredient, cause of action, limitation, and violation of the claim suit. All the above ingredients are established by the respondent, plaintiff in the claim, cause of action. Suit is filed in a time, the court fees paid under section 24 of this one. Therefore, suit is maintainable to terms. By respect to submission, even the CD, the plain copy, the limitation and aspect clearly stated the page number is about 35.
34 is the cause of action. 34 is the cause of action. It is submitted that fact stated in the plate to constitute the cause of action. The document number so and so is a forged one and defend number 1, 2, 3 are using the said document as a genuine forged document which is an offence under section 471 IPC made the signature of late Chandraya, who is the father of the plate. Chandraya who cannot sign and who is a Bhutani but took some impression only as such the cell says daily so and so dated so and so respect of land being by respect to submission that this is food for declaration. Declaring that cell deed is wide and the ground of that so for the limitation is aspect that we came to know only 2022 when the other side in that the respondent hearing filed a suit for mere injunction. Then only I came to know immediately from the date of knowledge that the appellant filed immediately the suit. But now in regard to the limitation, page number 35, the plaintiff submit that suit is filed declaration of a document 1947 so and so is null and void. The fact of forgery and using genuine as a forgery document came to the plaintiff hearing when the documents are filed OS 342 in IA 862 and the file of junior civil judge Shadnagar for served to the plaintiff hearing and suit with is limited. But the hint of knowledge has taken into consideration. When the trial court numbered the suit, but instead of for the inviting, they have the respondent hearing they are supposed to file a written statement. After filing a written statement, trial court has to decide. But instead of the commencing the trial, now they decided the AA rejecting plate that is illegal. In fact, the petitioner before not if they are in possession enjoyment over the property from the this is ancestral property. Defendants also the wholesaler over the property. It is not a dispute. The subject land is the joint family property. But admittedly, the petitioners before not they are in possession enjoyment over the same. Two IAs have been filed and is pending appeal. But suspension of sentence, another is injunction because my clients are peaceful possession enjoyment over the property. Now we are the pending suit, pending appeal that is only 15 minutes.
Yes, no. Yes, injunction is granted in the lower court.
High court what happened immediately after suit when the urgent notice has been ordered. Then immediately when I taken a notice to the other side, they filed a state of application without deciding that idea, that injunction petition. Now the high court
Issue notice. Issue urgent notice.
Status quo.
30th. 30.
Miller passed or matter? Miller.
Okay. Yes. SAV Ratnam garu.
Yes, Miller passed or matter.
Other side counsel is available.
Mr. Malleswara, what he said, he personally appeared before the court.
Yes, he said he's in the traffic.
Yes, Miller.
Now he has appeared before the court. Yes.
Yes, he is there. Miller, the order in the challenge.
1 minute. File enter the item number
77.
Unara counsel. Actually, another case is there. 1 minute, madam. Another passover matter is there. 22 and 23. Both counsel are available. Even yes. Two of 23 is allowed, huh? 2 of 23.
4 of 23 are also to be allowed.
Also to be allowed. See, condon delay, set aside abatement and LR application. Now you are arguing on these three IS.
4 IS.
4 IS.
To be allowed.
You filed counters in this? Ah. Mm. Okay. Mm. Mm. I tell me one thing, whether there is there an urgency in the CRP? It is 2019 matter.
My friend, my friend says there is, but what happened for all these years? Despite the fact that we are saying, yes, we are supposed to appear before this honorable court. That we appear. Kindly see when my friend has appeared. The IAS not brought by the court below. 2019.
No, because no. He says this IS has to be ordered along with the CRP. For that reason only, if there is an urgency, I'll take up all the IS along with the CRP. Otherwise, first of all, I'll allow the whether allow or
Whether my friend is saying one of his further proposed respondents, it to told me. Whether my friend find wakalat for them, wakalat need not take. Undertake. The decisions are done. That's nothing similar to this. They are already. That millet, he find millet wakalat kandiya.
suit is filed for? Suit is partition and separate position. Okay. So
Application the ordered millet so that there will be.
that is what I feel.
Because otherwise, tomorrow, my friend is trying to, but he wants to take a chance. No, I do not wish to take a chance on a procedural ground that this order, whatever order needs to be recalled. I do not wish to. Let my friend by Vokala, so why my friend says that the filing of Vokala is not necessary for the respondents. Who are the parties to CRP? Saying that I am unable to understand. Now the proposed petitioner command record wanted to command record. Already filed Vokala. I think not followed. Respondent number 1 died. But I wanted further already I filed Vokala. I am on record. My friend filed
See, LRs are not brought on record yet. See, once they're not ordered, no. These IS are not yet ordered.
My friend is not a target. That's the reason. That traditional that we now wife wants to come on record. First petitioner is none other than the son of the deceased. After 3 years, they file the public application. Nothing that I did not
See, if you do not want to file wakalat, we have to issue notice to the LRs also. It's pending. It's pending. Don't get confused, council. Please don't get confused. Let us see one by one. We'll take it. See, IA. First of all, we have to order. Let me see. Prasad Rani chapter first. See, you have no objection to allow the applications, right? Then see, you say let us.
Inclined to dispose of the CRP. We are asked to dispose of the CRP. Objection to allow the cases file my
I will let me see. We need to follow the procedure. See, when section 5 is there, condon delay petition is pending. We have to dispose of that initially before taking up other IAS. Okay, one by one. Please wait. Condon delay first. 2 of 23. 2 of 23. 2 of 23. Delay of 426 days. Okay. Now tell me, these whether notice is necessary for these LRs or not. Already these LRs are already on record, or notices has to be issued.
Applications are approved petitioner. They have filed the wakalat along with that, the applications are filed. Question of issuing notice to the proposed petitioner who are coming on this advertising wakalat does not arise. I think it's confused and it's saying to me, never report. You want to why and to consider. Don't make another personal problem. If you want to argue detail. And the above respondents in last I find my Masala and everything itself. Because allowed is after my knowledge.
Sir, proceeding should check.
To initiate the petitioner, suppose petitioner.
And the children look, sir. Proposed LRs already ordered into. The proposed LRs are respondent 2 to 4 and 7?
No. Respondent.
Proposed respondents are 16 to 20.
Yes. That is what I am submitting. My friend filed wakalat for respondent number 226, 227. This precisely my submission.
So notice అవసరం లేదు. Notice అవసరం. Ordered already. So IA 2 of 23, 3 of 23 and 4 of 23 is ordered. Okay, done. Now, ఇందులో కూడా CRP 2 item number 23 లో కూడా 2, 3 and 4 మూడు ordered. Now coming to the main CRP.
1 of 2023.
That is stay petition.
1 of 2023. 1 of 19 is stated.
1 of 2023.
2023 is there. Then find by me. Bring on record the proposed respondent 16 to 20 on record. As proposed respondent.
అది లేదు.
Respondent number 1 died.
1 of 2023 అంటే చూడండి. It's not there. 1 of 23, huh? అసలు యాక్చువల్గా 1 of 2023 is not reflecting in the cause list. The cause list. చూద్దాం. 1 of 2023. ఇదిగో 16 to 20. 1 of 2023 is respondents at 16 to 23. Personal notice is also notice is already ordered.
This is ordered. This notice ordered. Inside appearance.
1 of permission notice to proposed respondent. Even 19 is also ordered. 16 to 20. Post on
16 to 20. That is
1 of 2023. 16 to 20 and again I do not know. On 18/7/23 issue notice to proposed respondent 19 separately. Proposed respondent hearing brought on record. So as per the council has already filed wakalat for respondents 16 to 20. ఇక్కడ మనం ప్రొసీడింగ్ షీట్ లో రాసుకుని క్లారిటీ కోసం ది కౌన్సిల్ ఫర్ రెస్పాండెంట్స్ సిక్స్టీన్ టు 20. ఉంది 16 to 20. ఫర్ రెస్పాండెంట్స్ అయ్యాన్ని చూడండి నెంబర్. Okay. Anyway, are you ready with the main CRP? Already. Is already filed wakalat. ఇట్ ఈస్ ఆల్రెడీ ఆర్డర్డ్ అని చెప్తున్నారు కదా. ఇందాక నేను చూసా కదా, ఇది 1/23 కదా, 1/23. It is already ordered by this court only. It is okay. Yes, are you ready with the main CRP now or Friday?
There are some development that have taken place.
Okay, you get ready on 14th Monday. Tuesday. Why 2 weeks? He says he pleads urgency.
That will raise any objection at the time of marking. Matter of my friend, I would really, but my friend is tracking receipt of document. Receipt of document petition is still pending. My friend may not be aware. There are 3 applications filed, 2 are allow. One is reopen, another is recall. Third is received document. The trial court should have first considered received document first. It is only when the trial court found that the received document petition to be allowed, it is then only question of reopen and recall would arise. Trial court kept the received document petition pending. Then only recall reopen. The original document, the original idea which needs to be considered, jurisdictional factor is whether documents can be received or not by a person who has already availed such an opportunity once. And that is the situation. That idea is still pending, and these 2 years are ordered.
These two.
Let me get to that subsequent development.
Okay.
Basics in CRP 281 of 2019. First right. Is not by the present petition under 15 grounds of their paying is for to reopen the 15 minute number for the reception of document and evidence of.
This is reopen.
The other one is reception. That's to be correct. So to reopen the suit is also for the reception of document. The other suit lodged in TSHC for recall of PW. Now my friend says that in the grounds in fact that IA was not filed in the CRP. It's a petition filed under Rule 7, Order 7, Rule 14.3. But that is nothing to do with the present application with my respect to submission. Sir, he says that IA number 592 is pending. It was not filed, but in the grounds he stated that the record filed under Order 7, Rule 14.3. What should we say Order 7, Rule 14.3?
That is okay. See, we have only 2 CRPs right now. One is reopen and the other is recall. Okay, we'll pass orders only based on, because whether the received document petition is pending or not is secondary, because it is not before this court. So please get ready with the main CRP on 14th.
My friend is in the house. He has made my job very tough. That as if there is no application that is filed for received document. Now that I filed, I should have 2 options. One, we must summon the entire record. Other side, certified copy of document application filed 592.
Okay, 2011. That's all. 2011. Next. Okay. Council says he has some reason. Okay. On 2011 we'll dispose of. Okay. Next matter.
77.
ఎంత ఐటమ్ ఎంఎస్ ఎస్వి రత్నం గారు అన్నారు అదేనా ఎస్ఏవి రత్నం గారు
Yes, ma'am.
Yes.
Milord, the order and the challenge before this honorable court is at page number, your lordship may see. Docket order at page number, Milord.
1 minute.
Milord, my only submission is that, Milord, I filed additional evidence before the appellate court. The Milord, the order set aside by the Milord MRO. Under Milord, granted by the trial court in favor of the Milord respondent. That order of Milord was set aside by the Milord RDO on my application. That order was filed as additional evidence before the appellate court. While ordering that IA, it says that Milord, that order would be considered, that additional documents would be considered at the time of final order. But it was not considered. That is the only point, Milord, before this honorable court. That's why, Milord, I am seeking, Milord, remand of the matter to consider the Milord additional evidence which I have filed.
Okay.
That is the only simple point involved in it. As I have filed, as I have challenged, Milord, my further submission is that my land frame letter says that matter is to be remanded to the original jurisdiction. But Milord, the order of injunction, Milord, stands good. If it is, Milord, remanded back to the trial court.
Okay.
Otherwise, your lordship, Milord, set aside the injunction order and remanded back to the Milord trial court. I have no objection.
Court will decide. Okay.
For
I'll decide that.
yes, Milord,
Let the counsel complete his arguments.
well, to consider the additional evidence document which I have filed while ordering injunction.
Okay.
If that contention, Milord, if lordships reminds the matter to the trial court by setting aside the Milord injunction order, I have no objection.
Okay.
As matter, actually, I am in possession of the property and cultivate in the land. Harbor Act to Milord, revenue records are not the Milord title deeds at all.
Yes.
Has been filed against state board. State board not received the complaint of RDO. RDO are clearly mentioned that page 43. That's the point. 43 page. The second issue is the appeal subject matter involved in this week for additional municipal Warangal and issued temporary injunction order for respect of the survey number 24 between Gundir and the regular payment. Hence, this is IT dispute. It's a case of civil next. The suit filed by me is the injunction. Trial court clearly mentioned that I am in position that they granted the injunction. Basing on that injunction, they filed the CMA. CMA also dismissed it as the Trial Court findings. This is not for ITS suit. The commission is to be considered only due contest of trial. If they are claiming title basing on this order, they have to file the title suit. Not in the injunction suit. Further, I am giving you practicing. Even though they are having the title, they cannot claim the injunction to prove their position. The trial has to be conducted. Who is in position? And judicial hearing stated that the land allotted to them by the government, but they did not find any document to show that the government allotted to him as a poor person. Simply on maintaining the RDO, collision with the RDO, they obtained the fraud order, and now they are claiming that they are in position. Their position is not to the trial court as well. This trial has to be conducted, whether they are in position or not, who is the owner. If they claim the title, they have to file the title suit. Basing on this order, they are claiming the title. Clearly mentioned in the order, Your Honor. And also last paragraph also, Your Honor, in 43 page 43, if any dispute is they have to prove in trial court. The applicants and respondents divided into applications of title over the land as per the order. Title, it is for the but the revenue orders cannot prove that title. Even the appellate court are the court stated that several cases, even if revenue cards are there, it cannot be said that they are the owners. If they are owners, they have to file the title suit to prove their title and inject position. And as per my documents, your exhibits A1 to A5, trial court marked exhibits A1 to A5, and they made conclusion that I am in position. That's why granted the injunction.
Basic and the revenue record.
Even though you are article of order, they stated there is no RWAR book is not there. How they came conclusion that they are the title owner? The order also is clearly mentioned. For a moment, I show you the land is been considered. Page 41, Your Honor. For a moment, and this is Your Honor. The the respondent stated that the period of worldwide. The I know reported that the total extent of survey number is so. The Parigala Premada, Parigala Srinivasa, again, products are celebrated such land of total extent to acre of land. As coming to share of the Parigala market, year 1969-70, and his name was also recorded in village Pahani, village Pahani. 702/4 as an offering. After demarcation, a plan has been inherited to the particular family and subsequently the name of particular Sepulaka. Then the was incorporated in the offering column and the connect to acres in the year 1984-85. And the same was considered of 13-4. They belong to SC Maria caste. One Sri Guntur Venkataya, son of Malaya, and over village belonged to Thoda, BCB caste, had created one sub Sada Bainama dated from 1969 by showing that they had purchased the land to an extent of 2 acres in the state of survey number 7 from Omodi Rajamalaya, son of Venkaraya. And based on such document, he got Pattada passbook, bearing number so with Patta number 2. Moreover, the Kanzal Agro file is not available in the record. Agro record is not there. I am claiming this is the Patta land. They claiming the assigned land. Government allotted to them. It is clearly mentioned by the order that the land is Patta land. In the lately in the appeal, Your Honor, page 32, Your Honor. Fourth paragraph. The applicant stated that about 50 years ago, the government has allotted the land to Bargera Chinnamana as being a land person. If their claim is true, it is the assigned land. But in the record, it is a Patta land. In the provision of the RDO, they obtained the fraudulent order. Basing on that, now they have filed this PRP. Is this just a method to trial has to be conducted in trial court. If they are having any claim in the initiated property, they have to file a title suit. It is clearly mentioned in the judgment, Your Honor.
Milord, I am permitted to Milord, you reply arguments. Your Lordship may say.
No, he has not concluded. Council has not.
Sorry.
It has been held that clear fact that the question of title may have to be gone into studying whether an injection can be given or not. Is not any specification for holding the clarification of title and for injection. There cannot be sued only for an injection. The presence is only for conveying injection. Therefore, the lower appellate court should have and the character of the case confine itself to dismissal one and ground that the appellants are failed to prove that they to show that they are in position. But here, that This has to be done, but the declaration that the applicants are not the owner was not necessary. They are owner or not necessary. The position has to be proved. Here I am in position from the year 1969. My name is also incorporated in Pahani and exhibit to the P1 to P5 are clearly shows that and my name is incorporated in the very record. These are the lands that Patala, as per the RDO order and clearly stated in the RDO order, TSHC order, basing on that they are claiming that they are the owner. If they are really they are owner, they have to find the title sheet to prove their title. That is my.
Yes. Millard, you will actually see Millard page number 61, Millard, that is a trial court order. Basing on which Millard the injunction was granted. These are all Millard Pahanis. And Millard Pattatar passbook. Whereas Millard, the RDO, you will actually see the RDO order at page number 43, which my learned friend Millard relying upon. Previous paragraph. Otherwise, Millard, I am permitted to read Millard entire order, but Millard, last time already this matter was discussed extensively. But Millard, just Millard, in view of the above, your lordship got it, Millard, page number 43.
Yes.
In view of the above, as per the Tahsildar report, your lordship got it, Millard, 43.
Yes, I got it, Amma.
As per the Tahsildar report, it is observed that the Tahsildar has not followed the ROR Act. Hence, the Patedar passbook and the title deed issued by in favor of the respondent in respect of survey number so and so to an extent of 2 acres situated in so and so village are set aside and cancelled. If the Millard, that order is cancelled, then automatically Millard, the portion under which Millard she is claiming the Millard possession, under the documents under which she is claiming the possession, they are also cancelled. She established the possession basing on the Patadar passbook as well as Pahanis. Whereas Millard, these are cancelled by the order of the RDO. Millard, my only submission is let the Millard court consider this document. I am not seeking any power by order here. Millard, even Millard, you will actually see Millard page number 31. The flaw committed by the Millard appellate court. Page 31, Millard for my benefit. It is Millard petition under Order 41, Rule 27. Your Lordships got it, Millard. Reported no counter. They did not file any counter, Millard, what my learned friend is now saying. The order, Millard, is not tenable as it is falsely obtained. Reported no counter. Call with CMA 2611 on 26/11/2019. That is, Millard, naturally, in every court, Millard, additional evidence would be considered at the time of final hearing. It is an established law. So, Millard, while disposing of the CMA, that appellate court did not consider this document. That is my only submission. My only submission is that when the court itself, Millard, observed that Millard, that additional document would be Millard, let it be discussed in Millard and let the court pass an order against me. I have no objection. But there was no discussion at all. It was not at all considered. While passing a Millard final order, that is the only crux of the case.
Okay. Heard.
Millard, I am only Millard seeking remand of the matter to the appellate court.
I understood, sir.
There you are. Akbar Act is not there. Not available in the Act record. And here they stated that they are not followed the Akbar Act. The Akbar Act already itself clearly shows that it is illegal.
Yes, sir. Heard both sides. Orders result.
Millard, stay may be extended, Millard, till then. Stay may be extended until then, Millard.
Orders date ఇచ్చేద్దామనైతే. For orders posted to 23. Stays extended till then.
Much please.
The injection should they were telling that the title. So they are not by the title.
Also matters. 6 no రాలేదు మార్నింగ్ నో రిప్రజెంటేషన్ అది జడ్జ్మెంట్కి వచ్చింది ఇది రాంగ్లీ పోస్టెడ్ కాజ్ లిస్ట్ లో ఫర్ ఐటమ్ నెంబర్ 6 చూడండి ఫర్ జడ్జ్మెంట్ అని ఉంది జడ్జ్మెంట్ ఎందుకు వస్తుంది అంటే the caption for no representation either side on call, hence posted and a word protect. Posted to 24. For orders and పెట్టాలి for judgment అని ఎట్లా పెట్టేస్తారు డైరెక్ట్ గా ఇది సురేష్ టైప్ చేశారు అందుకని గుర్తొచ్చి కవక వచ్చినట్టు